My name is Wes Rist. I am the Director of Education and Research here at the American Society of International Law. For those of you who don't know ASIL, we are a nonprofit organization that's been around for 106 years. We focus on advocacy or information and education on international law issues. And that is one of the better parts of doing this kind of job is we get very timely things that happen. And so today is a very exciting event. We have a wonderful panel who's going to talk about human trafficking today. And of course, all of you, as you came in, were able to pick up some of the information downstairs on the table. And in there is the executive order that President Obama issued less than a week ago addressing this particular topic. So we're in a very timely event that's going to talk to us a little bit about how that is. We have a wonderful panel of presenters. I'm not going to bother introducing all of them because Martina is going to. She is our wonderful connection with the Open Society Foundation that we've worked with on a number of other interesting activities and cooperative events. We look forward to any questions that you might have about ASIL after the event. The staff here would be happy to answer any questions you might have. If you're students or young professionals, we would strongly encourage you to think about membership in ASIL. This is the kind of event that we routinely have. I've been here for all of 5 weeks, and I've been to about 10 events like this already. It's incredible. So take advantage of that opportunity if you are a student or a young professional getting started in this field. Otherwise, we welcome you to ask any questions that you might have. I believe we're going to have some time for question and answer from the audience at the end as well. So without any further ado, I will turn it over to Martina.
Thank you very much. Welcome, everyone. It is absolutely delightful to see such a huge crowd here today at the American Society of International Law to talk about two of my favorite topics, human trafficking, diplomats and domestics, and also human trafficking as it relates to government contracts. I'd like to start by first thanking Jenny Green for running over from the Supreme Court. But I would like to also thank the American Society of International Law, the Washington Foreign Law Society, and the Open Society Foundations who sponsored this event and made it possible. Veronica and Wes, who both work here at the American Society of International Law, have been really instrumental in getting everything together. As Wes mentioned, this has been an enormously important week in the field of human trafficking, with President Obama making a speech at the Clinton Global Initiative on human trafficking, where he focused really in an excellent way on human trafficking and government contracting, an area of human trafficking and forced labor that has for far too long been ignored. He issued an executive order, which you got at the materials downstairs, and it may be a little bit odd for these two issues to be at one table. We have some excellent speakers today who are really the leaders in the field of fighting human trafficking and looking at accountability in these areas. But how do diplomats and government contractors all fit under the same rubric? I think that many of us in the activist and the advocacy and the legal community view government contracting and trafficking by diplomats under the same paradigm of an area where there is actually no accountability. It is an area both in the government contracting sphere and also in the diplomatic sphere where what we see is impunity rather than accountability. And so to further flesh out what government contracting and diplomats, how they relate to human trafficking and the larger conversation about human trafficking and justice and accountability, we have four really amazing panelists today. I'm going to read their bios in the order in which they will speak. We're going to start with the government contracting side, but we're going to begin with the lawyer, Stephen Watt, to my far right, who is an active attorney litigating cases in both spheres. So Stephen has worked quite a great deal on the government accountability, government contracting accountability front, but Stephen and I have also litigated diplomatic cases, trafficking cases involving diplomatic immunity. Stephen Watt is a senior staff attorney at the Human Rights Program of the American Civil Liberties Union, and he focuses there on civil and human rights litigation in domestic courts as well as international tribunals. He's counsel in a host of state and federal cases, and having litigated cases with him, I can say that he is a brilliant advocate, a really excellent attorney. He has focused not only on trafficking and forced labor, but also juvenile justice, women's and immigrants' rights, and prison conditions. He's looked at U.S. rendition policy, detention, and interrogation policies. and has also done work on Guantanamo. Before he went to the ACLU, Watt was a Human Rights Fellow at the Center for Constitutional Rights, where he focused on post-9/11 civil and human rights litigation. So Stephen will start, and let me just go through the rest of the introductions very, very quickly. Our second speaker is someone, Robert Reed, to my far left, whom I've heard speak on numerous occasions at events sponsored by the International Peace Operations Association, Association of Government Contractors, and also other conferences. But Robert Reed is the leading expert in the United States and at the Department of Defense on the Military Extraterritorial Jurisdiction Act. Since 1997, he has been the Associate Deputy General Counsel for Military Justice and Personnel Policy for the Office of the General Counsel of the Department of Defense, where he provides advice relating to the Military Extraterritorial Jurisdiction Act, all military justice matters and criminal law issues, and military jurisdictional issues over active duty and reserve forces, civilian and contractor employees with the Department of Defense, and under the Uniform Code of Military Justice. He has provided guidance to the Department of Defense on the Department's annual review of the Manual for Courts Martial and Presidential Executive Order changes. And he provides litigation assistance to the Department of Defense on cases including several that have gone to the Supreme Court. Before he moved to the General Counsel's Office at the Department of Defense, he was the active duty Air Force Judge Advocate for more than 27 years, retiring with the grade of Colonel. So let me start with those two introductions, and then as soon as we switch over to the diplomatic side, we can do Jenny's introduction and also Susan's. So Stephen, would you like to begin?
Sure. So again, Martina, thanks very much for the invite, and I think it's very timely and became even more timely to hold this panel today following the executive order last week addressing trafficking in forced labour by military contractors. Now, this is an issue, the trafficking on government contracts, that I knew very little about until spring of last year, I think like the bulk of the American public. I had a meeting with Sarah Stillman, who was investigating an issue for a report, for an article that came out in the New Yorker in June of 2011, which was looking into the issue of trafficking in forced labour on government contracts. So a shout out to Sarah for actually educating me on the whole issue, and I would strongly encourage any of you who's interested in this issue to read that article, as I say, in the New Yorker. And what she was interested in the ACLU doing was she had a number of FOIA requests, Freedom of Information Act requests, on the issue of government contracting and trafficking and forced labour policies and practices. So she wanted those litigated, which we undertook to do, and we've got ongoing litigation, and we got a settlement from the US government, from the Department of State and Department of Defense, and they are in the process of producing numerous documents documenting the issue of policies pertaining to forced labour and trafficking. And rather than just post those documents to the website, which we are doing, we decided to document this in a human rights report. And I, together with the Yale Lowenstein Clinic, we put together a report called Victims of Complacency, and it looks at the issue of ongoing trafficking and abuse of third country nationals by US government contractors, and it pulls together secondary documents, articles, newspaper articles, and also first-hand accounts of former third country nationals, and I'll describe who those are in a minute, who've been subjected to trafficking on government contracts. So this is the sort of end result of our advocacy on trafficking and forced labour on government contracts. So what I'd like to do for you today, in my time allotted, because I've not got a lot of time, it's about 10 minutes, so you give me a shout, with 2 minutes to go, is just give you an overview of the contracting process and show how they operate and how they potentially open the door to trafficking and forced labour of foreign nationals. Also in the report, and I think it's very important, is we document the kind of waste of taxpayer dollars in the contracting process as a consequence of trafficking forced labour. But I don't really have time to go into that, but it's in the report, and I encourage you to to have a look at that aspect of this issue as well. So government reports indicate that in Iraq and Afghanistan alone, there's some 174,000 labourers that are contracted to perform services in Iraq and Afghanistan. And of those, 70,000 are third country nationals. And who are third country nationals? They are individuals from India, Nepal, Philippines, impoverished villages in those countries who are contracted to perform services, logistical support services to the troops and diplomatic missions in Iraq and Afghanistan and other countries. They provide food services, construction work, security and the like. Crucial services to the troops and diplomatic missions overseas. And here's how the contracting process works. The United States government, Department of State, Department of Defense, has a sum of money to provide those services, and rather than provide them directly, contracts them out to what's called a prime contractor. And some of those corporations, very large corporations you'll be familiar with, KBR for example, would be a government prime contractor. And again, rather than provide the manpower for these services themselves, they'll subcontract out to subcontractors, most of them fairly large corporations based in the Middle East, to provide the manpower that they need to service these agreements. And they in turn will they will hire, these subcontractors will hire recruiters in companies in India, Nepal, Philippines and like, to directly hire these individuals on contracts. And another actor in the contracting process that you need to be familiar with, so you know how the trafficking and forced labour works, is what's called loan sharks, local loan sharks. They're people that will lend money to these individuals, these third country nationals. You know, they're individuals that, say, the Indian nationals who we interviewed, they're earning on average less than $2 a day, but they will contract with loan sharks, and I'll tell you how they fit into the sort of the overall scheme as we go on. So what happens? These local recruiters will go into these villages, and from our investigation into this report, they seem to target villages that are far away from the spotlight. So they're farming and fishing villages in rural India, for example. They'll go into those villages, they'll set up a fly-by-night operation, they'll put a posting in the local press or just locally in the villages advertising for jobs. They'll not necessarily say where those jobs are, and they'll advertise for very large sums of money for these individuals. You say $1,000 to $3,000 a month, they'll say that the work will pay. For janitors, food service people, they'll not necessarily say Iraq and Afghanistan, and by and large our investigation shows that they won't say that. They'll actually indicate, these local recruiters, that they're for Middle East countries, safe Middle East countries, certainly not in war zones. They'll have a day of hiring, they'll promise them high-paying jobs, and they'll also say that there's a recruitment fee that goes with that job. So they'll say, and the recruitment fees we found vary from sort of $2,000 to $5,000. Again, taking into account that they're earning $2 a day, that's a huge amount of money. So what they'll do is, in order to pay off that recruitment fee that they're going to be charged, they'll contract with a local loan shark at a rate, huge interest, 30 to 50% we found. To repay that money, thinking that, you know, if we're earning between $1,000 to $3,000, which is a huge amount of money for us, then we're going to pay that off in sort of 5-6 months, so it's worth it. So they'll take out that loan. They'll often, you know, they'll mortgage their homes if they have them. And these loan sharks are usually in local villages, so they're immediate contact with their family members. So they get sucked in, high-paying jobs. They're going to pay that off. They fund the recruitment fee through the loan sharks. There's no written contract generally in this process. That's what we found. There's nothing in writing. And even if it were, many of these guys are illiterate, or if the contracts are provided, they're provided in English, which most of them are not familiar with. But generally, there's no written contract provided, and that's a very important piece of the trafficking and forced labour puzzle. They take out these huge fees. They're hugely indebted to the local loan shark. They arrive at the airport. They hand over the $5,000, whatever the recruitment fee is, and they're transported. And here would be a good example of what happens next. Is you're transported, you arrive in Dubai, and the women who are at the centre of Sarah Stillman's piece in the New Yorker, they came from Fiji, they land in Dubai, they thought they were going to be beauticians in a hotel in Dubai, and they're told when they land, actually you're not going to be here in Dubai, we're going to put you into Iraq and Baghdad, and you're going to be a beautician on military bases there. They then consent because they've incurred huge debts back in their home country, and they agree, then they consent oftentimes to go into Iraq because they've got no choice. So they're in, then once in country, the living and working conditions are generally abhorrent, and there's no oversight over what those conditions are. Their living and working conditions, we found they'll work 7 days a week, 12 hours a day. And an interesting excerpt from one of the rare incidents where we actually had a written contract. The contract provided that they would work 12 hours a day, 7 days a week with no time off, for a year. That's the kind of living and working conditions they're operating under. That is, in our view, it's a trafficking situation, and once they're in country, it's a forced labour situation. There is laws to tackle that in this country, most notably the TVPA. But yet, we've found that there's been little by way of enforcement of these laws. There's been little by way of investigation when allegations are made, and we now have those allegations documented in FOIA documents, and many of them here in Victims of Complacency, the report. The report documents that it's ongoing and pervasive, these types of trafficking and forced labour, and also deceptive recruiting practices that don't perhaps in and of themselves amount to trafficking and forced labour, but deceptive recruiting practices such as the high recruitment fees and the like, that puts these individuals in a position where they're subjected to bonded labour. And if I could, I've got time just briefly.
You've got 2 minutes.
EO, perfect. So the EO is, as Martina says, this is a great contribution to the issue, and I think its biggest contribution is elevating this issue of trafficking on government contractors, or on government contracts, at the presidential level. I think that's really crucial to us moving forward and trying to address this problem. There are a number of positive developments here. As the EO says, it clarifies what the law is and that there are obligations on the US government to take steps to prevent trafficking and forced labour. It imposes responsibility on all levels of the contracting process of the prime contractors, the subcontractors and local recruiters to ensure that there's a zero tolerance policy on trafficking and forced labour. That's great. The abolition of recruitment fees is huge. Maybe there's, and I just sort of finish up, there's a couple of issues that, on first impression I think are going to prove problematic, and it's enforceability. That's still going to be a big problem, and I think that stems primarily from, there's some fixes that I could see being made here that would address that particular problem, is provision of a written contract before departure in language in a language that the TCNs actually understand. That's not provided for in the EO. I think there's perhaps ways and means by which you could get that in there as an effective anti-trafficking measure. But it doesn't. It would be good to make that explicit, the provision of a written contract. Also, I think what would be good in terms of enforcement, and to sort of think about down the line is holding the prime contractor responsible for the trafficking and forced labour of its subcontractors. I think that's feasible, and I think it will be something that really would effectively address the trafficking and forced labour that's currently happening on these in the government contracting process. So I'll end there, and I'm happy to take questions.
Thank you, Stephen. That's excellent. And the enforceability question that you raised at the end is an excellent segue into Robert Reed's presentation. Please.
Good afternoon. I first got involved in this extraterritorial jurisdiction issue back in 1996 in a different context. And the context was that the military deployed all over the world, that military installations had civilian dependents, wives, other people assigned to the base were employees, contractors, civilian employees. And what was happening was that the Supreme Court in the 1950s said that the military did not have any criminal jurisdiction to prosecute the crimes that they may have committed in that area. And as a result, if the U.S. law was not extraterritorial in its application, in other words, its reach only went to the borders of the United States, and you were overseas, then the United States didn't have any jurisdiction to exercise criminal jurisdiction. So then you look to the host nation in those countries. And sometimes because they are Americans that are committing crimes against other Americans, the host country either could not or would not prosecute. So you ended up with what we call this jurisdictional gap.
Can you speak up a little bit?
Sure.
Thank you.
We ended up with what, is this working?
I think it is.
We ended up with what was called a jurisdictional gap, where the military commanders over there, when these incidents came to their attention, the only thing that they could do is administratively return them to the United States, in other words, get them out of the theater, which was unsatisfactory to the military for almost 40-something years in efforts to try to get that gap filled with some kind of jurisdiction. And that's what happened in 1996. We finally got legislation that allowed a joint DOJ-DOD task force, and I was a member of it, to come up with determining whether or not the UCMJ was adequate, and if it wasn't adequate to address this, then come up with a proposal as to how we could address this problem. We came up clearly saying that because of the way the Supreme Court had ruled and the military court had ruled, that the UCMJ jurisdiction did not extend to civilians in that context. So we turned our attention to expanding federal jurisdiction in federal district court, which is what we did in drafting and ultimately getting passed the Military Extraterritorial Jurisdiction Act. And essentially what that said was, if you're a civilian and you're overseas and you're working for the Department of Defense, or accompanying the Department of Defense, if you commit a crime, which is a felony level crime if committed here in the United States, punishable by a year or more, then the federal district courts in the United States would have jurisdiction to prosecute that case. So that gap was filled as far as the Department of Defense was concerned. The problem was it didn't go beyond employees and contractors and dependents of DOD. Department of Defense people. And ultimately, through passage of time, as this statute was developed and regulations were issued to implement it, then they started looking beyond the realm of the Department of Defense. And that's when they amended the MIJA statute, Military Extraterritorial Jurisdiction Act statute. I hope you can let me say MIJA because that's too long. But after the MIJA statute was passed and it was realized that it had a very narrow focus, and they liked how it was coming to be as a federal statute, they wanted to expand it beyond that to other federal agencies because they realized there are a lot of other federal agencies that have civilian employees, contractors, and dependents that are working outside the United States that can fall into the same trap of committing a crime and no jurisdiction. And so they amended it and they said if you work for another federal agency whose duties relate to supporting the Department of Defense, so it's still that nexus, if you will, for jurisdiction, then the MIJA statute would apply to you as well. Well, that was fine, but that was just only a baby step in the direction of covering all the civilians that could get into trouble in an overseas environment. And for the last couple of years, since 2010, 2011, Congress has raised but not yet passed what we call a Civilian Extraterritorial Jurisdiction Act. And the intent of that act was to be a vehicle by which the same people, dependents and contractors and civilian employees of other agencies, without the requirement of being connected with the Department of Defense, could be subject to federal district court jurisdiction in the United States. Okay, so that's kind of the broad brush of that. It did not talk about specific offenses. Okay, the legislation doesn't talk about specific offenses. It only says that the offense must be a felony level offense if it was committed in the United States. You're looking towards the real analytical process is looking towards the individual who committed the offense, because he has to fall into that category of being connected with, dependent of, etc., in order to have jurisdiction in that particular area. And so a lot of the analysis and the investigative analysis is trying to draw that linkage between the individual who committed the offense and the relationship with the Department of Defense, and it's still that way because the CJA hasn't passed yet, or some agency that's supporting the Department of Defense, in order to have that jurisdiction. Now, this body of law is merely a jurisdictional hook to give the federal district court jurisdiction over these people. The crimes that they commit, such as trafficking in persons and other crimes, may be on the federal statutes and have their own jurisdictional basis upon which they could be prosecuted. And so when we present a case, or the Department of Defense presents a case to the Department of Justice, which makes all the calls in this area, by the way, the Department of Justice then can look at the case and they can decide that they prefer the jurisdictional basis of contract fraud overseas as more easy to prosecute and easier to serve their purposes than the media jurisdictional basis that we rely on. It's going to be their call on that. So anyway, after the statute was passed, then the statute says, well, we're not going to put it into effect until we have the Department of Defense, in consult with the Department of Justice and the Department of State, come up with regulations that would be implementing that. That was a big exercise that we went into. The media statute was passed in the year 2000. We went into a big exercise with all agencies involved in 2000, first part of 2001. And then, of course, we ended up with 9/11. And 9/11 blew all planning and all attention to the four corners of the world. After dealing with those issues, finally, we decided, or I decided, that I was going to draft an implementing regulation. And rather than try to do it as a group process, I would draft it and then ship it to the Department of Justice, Department of State for their review, coordination, modification as they recommended. And that's ultimately what has happened. There's a CFR provision that sets forth the regulations implementing media, and there's a DOD instruction, which is our regulations, if you will, that's a little more robust, if you will, than the federal rules. Our CFR provision that kind of walks people through the process of how these cases go. To give it to you in a nutshell, just to give you an idea of the difficulties of these cases. Many of these cases are on the four corners of the world with foreign national witnesses, with evidentiary chain of custody issues that are not handled in the exact same way that criminal law requirements are in federal district court. You have, when you get into federal district court, the federal rules of evidence apply, and so therefore the investigation and the evidence and the witnesses and all the rights to confrontation and all that sort of stuff that the Constitution affords in a federal district court prosecution are going to have to be complied with. You have to bring that case, if you will, that happened in the outskirts of Afghanistan. You have to be able to prosecute it in the federal district court in Washington, D.C., if you can imagine that process. Now, what the Department of Defense does with its cases is they do an investigation of the crime there. They write up a report of investigation. That report of investigation then comes up through command channels to the Pentagon, to the General Counsel's office, to my desk. Then I review that and I make the formal transmission of the case on behalf of the General Counsel and the Secretary of Defense over to the Department of Justice, saying, here is a case, we've wrapped it up as neatly as we can, here's the witness statements, here's the evidence, and we give it to the Department of Justice and we make a recommendation to the Department of Justice that they pursue major jurisdiction if they can. They review it and they make a decision as to what U.S. attorney is going to prosecute. If it's somebody that has no connection to the United States, it's going to be the District of Columbia office. But if it's somebody that had a connection to the United States, then you've got to go through the federal venue statute. And the federal venue statute says, well, the jurisdiction is going to be where the person is first brought. That means in handcuffs, if you will, where he's first brought back to the United States in custody. And if it's not there, then it's going to be the individual's last known address in the United States, residency in the United States. So can you imagine you're the U.S. attorney in North Dakota and all of a sudden you're getting this case from Afghanistan that you're supposed to prosecute because the offender's last known address was in Bismarck or someplace like that. So there was a big learning curve for U.S. attorneys' offices and U.S. attorneys, not to even mention military attorneys, in doing this. When we first started getting the word out and trying to educate people on these particular statutes, they thought it was MIHA, MIJA. They had no idea what we were talking about. They'd never heard of it before. They'd never read the statute. They had no training on it at all. So we're basically coming at them with a blank slate and saying, we want you to prosecute this case. And this guy's saying, look at my plate, it's full. You want me to take this case from Afghanistan and put it over here? But that's what the law requires, and that's what we have pursued. We, in the last several years, since 2005, we've processed about 128 of these cases up through the system. And of those, about 56% of them have been either prosecuted or in the process of being prosecuted by the Department of Justice. They don't all include trafficking in persons issues, okay? They cover the gamut, from homicides and common law crimes to child abuse, to child pornography, to larceny, to embezzlement, aggravated assault, sexual assault. So it's a whole gamut and range of offenses that they get involved in. And it's a process by which we've been on a very steep learning curve for a lot of people. We have implemented through the service secretaries, that's how we kind of operate as far as managing it. The service secretaries, we've levied upon them the requirement that they must inform all of the people who are getting deployed to our overseas location that they are in fact subject to this jurisdiction. And that's important because if you don't know about it, then you think you're free of any endangerment if you commit these offenses. And so you kind of let your hair down and go wild, and all of a sudden, you find out you're subject to this jurisdiction. If we can inform you of that and put you on notice that just because we deployed you to Afghanistan as a civilian or a contractor doesn't mean that you're not going to be prosecuted or capable of being prosecuted in the District of Columbia, then perhaps you'll abide your, it's a deterrent effect that gets you to comply with the laws that are on the books. We have training sessions that we give every year, mandatory training sessions to all military folks on trafficking in persons. I'm just in the middle right now of doing the review of the slides and stuff for online training in that area. We did it last year. We have conferences. All of these mechanisms that we have is trying to get the information out to, one, let them know that there is such a thing called trafficking in person. Number two, let them know that they can be wrapped up in that if they don't behave themselves. And number three is the point that I try to make is these are not, if we can bring a good case and wrap it up well, then the Department of Justice has prosecuted some of them. They're not easy because I explained to you why they're not easy. But they have, in fact, prosecuted several people on that. One of the issues regarding third country nationals, somebody just mentioned third country nationals, the MIJA statute excludes people who are host nation employees or contractors. So in the example that was being used, if you're over in Afghanistan and you hired an Afghani to be an employee or a contractor or whatever, and he commits his crime in Afghanistan, then MIJA doesn't apply to him. That's an exception to the MIJA statute. That's because the assumption is the Afghanistan country will take care of its own folks. If you took that same Afghanistan employee and you shipped him over to Iraq, just using the war zone for common discussion, then because he's a third country national to Iraq, he would be subject to MIJA jurisdiction, okay? So when you're analyzing these cases, you have to analyze who the person is and what his status is and what statute you're going to move under before you will have jurisdiction. So it's a little more complex than your normal variety common law crime here in the United States, where it's pretty clear if you did something in Fairfax, Fairfax police can have jurisdiction over you. I got a warning that 2 minutes is up. I just wanted to give you a background on the why for the legislation, the difficulties associated with doing these cases, that we are in fact doing these cases. When I testified before Congress to get MIJA, they asked me specifically, well, how many cases do you think you're going to have a year? I said, nah, maybe 6 or 7. Well, we've done 128 in the last 5 years. At least they've come through me to justice. And so as a result of that, I think it's growing. And as people become more familiar, more aware of it, they're more comfortable with dealing with the issues associated with it. Before, it was like, oh my God, I don't even know how to spell it. I'm going to prosecute it? I don't think so. I think we've gone beyond that point at this time. We're not where we should be, but we're a lot better than we were. And I'll stop there and answer questions as you get there.
Thank you so much. I think you can see why these two folks are really just the ideal people to address these issues. I want to congratulate the ACLU because I think the executive order is really largely a reflection of the really terrific work that they did on the Victims of Complacency report. And the URL for that report is available, I think, on the materials. You can get it on the ACLU website. So we're going to switch gears for just for a while and talk about trafficking in a slightly different context, which is trafficking as it relates to diplomats and diplomatic immunity here in the United States. And again, we have two of the premier experts in the United States on this area. It's an honor for me to introduce Jenny Green. Jenny has just come from the Kuwait argument before the Supreme Court, a case which she worked on among other international human rights cases under the Alien Tort Statute. But it's particularly poignant for me to introduce Jenny because Jenny Green is the reason that I became a lawyer. I met Jenny Green at the Women's Conference, the United Nations Women's Conference in Beijing, China, where I was leading a Russian delegation in 1995, and heard Jenny speak at that time about her really groundbreaking litigation under the Alien Tort Statute against perpetrators of rape as a form of genocide and a war crime in Bosnia and Herzegovina. That was an incredibly moving talk that she did in Beijing, China at the UN Women's Conference, but it was just an indication of the really remarkable work that she has done back here in the United States. Jenny Green is currently an associate professor at the University of Minnesota, where she is a clinical professor. And before that, she was an attorney, a senior staff attorney at the Center for Constitutional Rights. She's been an adjunct professor at the International Women's Human Rights Law Clinic at the City University of New York School of Law. She also served as the clinical project supervisor and administrative director of Harvard Law School's Human Rights Program, where she supervised students' clinical research and clinical projects. She received the Yale Law School Orville Schell Center for International Human Rights Fellowship and the Mark DeWolf Howe Fellowship, and served as the editor of the Harvard Human Rights Journal at Harvard Law School. She has worked on multiple cases, federal cases in U.S. courts since 1990, including the case that she talked about in Beijing, the groundbreaking case of Doe versus Karadzic. She recently settled a case that was initiated in 1996 in her capacity with CCR, Rewo versus Royal Dutch Petroleum. So clearly Royal Dutch is a frequent flyer in Jenny Green's jurisprudence. They recently concluded a $15.5 million settlement for the families of activists murdered in Nigeria. Jenny has a publications list that's 4 pages long. So I recommend her writings to you. And then I'd also like to introduce Susan Benda. It's an honor to introduce Susan Benda, the attorney advisor of the Office of Legal Advisor at the Department of State as well. Susan has been an attorney advisor in the Office of the Legal Advisor at the Department of State since 2000. She's currently working in the Office of Law Enforcement Intelligence, and she has full responsibility for trafficking in persons issues. So she advises Ambassador Lucy DeBaca in the TIP office on trafficking in persons issues, also related to the State Department's annual Trafficking in Persons report. Before that, and this is the capacity in which I got to know Susan Benda quite well, Ms. Benda worked in the Office of Diplomatic Law and Litigation, where she was the attorney responsible for the department's efforts to address the abuse of domestic servants by diplomatic mission personnel in the United States. She received her J.D. magna cum laude from Georgetown University Law Center, and before joining the Department of State, she was the Director of Governance Programs at the National Democratic Institute for International Affairs. Susan Benda also worked at the ACLU. My experience, and she has attended multiple meetings at the Organization for Security and Cooperation in Europe, which also is now focusing on accountability for diplomatic trafficking issues around the world, and particularly in Europe. Having worked with Susan Benda professionally, often on the other side, I can say that Susan is a remarkable and meticulous and careful lawyer who zealously represents the point of view of her employer, the Department of State. So let me leave it at that and turn back to Jenny. Jenny, if you can start us off with a discussion of diplomatic.
Sure. Well, I'm going to talk about this just basically from the lens that, the perspective that I've looked at it, which is as a lawyer with clients and what their rights are. And the general category is, as you may have heard, is some of the materials you looked at in the packet, talk about the diplomats who come to the United States, bring with them domestic workers, and then something goes terribly wrong. So one of the cases that I worked on was a woman who was brought from India and worked for a Kuwaiti diplomat and his wife in their private home. And there's a series of other cases that have wound up in the United States courts because the person has come into the United States, often under false pretenses. They've been told they're going to get this contract where they're going to be well paid, they're going to be allowed vacations, they're going to have a reasonable workload, and instead they are working 16 to 17 hours a day. They are not allowed to leave the apartment or the home of the particular diplomat, and they are subject to physical abuse, psychological abuse. There's a variation of what Stephen was talking about, where they're basically indentured servants. They're told they can't go home until they've worked off their contract, and they don't have the money because they're getting paid at such a miserable amount. And this violates numerous provisions of U.S. law, and I'm going to go through some of them. But then there's a mixed result in terms of what kind of accountability is in fact possible. You can bring lawsuits in the United States court, and we do that as a last resort. The U.S. government has been terrific at trying to build preventative measures to decrease the number of these types of cases, but there's still a problem when there is a diplomat who does bring in a domestic servant, and there is a situation of abuse, and there's a then what situation. There are 2 cases that have settled, and I'll talk about them in a bit. And then there's also cases where there's a default judgment. There's a U.S. court goes through, looks at the facts, the diplomat may not even show up, and then the court does what their recourse is to say, well, you can't just ignore our court. You know, we're going to proceed, we're going to listen to the facts, and we're going to issue a judgment. But then there's a big then what? You know, you've got a judgment on the books. Can you enforce it? And what happens to the person who's been held responsible by a U.S. court? So I'm going to talk just about some of the specifics of some of the cases. One of the cases, which was brought by Zebora Mazengo versus a Tanzanian diplomat, Alan Mazengi, and his wife. She was recruited, told that she was going to work for $900 a month. She got a fraction of that. She was told she'd work 8 hours a day, 5 days a week, get holidays off, time and a half for overtime, 2 weeks vacation. It sounded like a great job, so she comes to the United States. What happens is she worked over the next 4 years, 7 days a week, 6 a.m. to 11 p.m., responsible for 3 children, cooking, cleaning, raking leaves, shoveling snow, cooking food for a catering business that the Mazengis ran out of their home. She was working so hard that she wound up having a serious problem with her foot, required emergency surgery. They required her to work the same day that she came home after the surgery. And she was put outside in the cold wearing a t-shirt and shorts. Received little to no medical care. So she, and ultimately she was able to get out of the situation and brought a claim in the United States court in 2007. And the claims that she brought were for trafficking, violation of the Fair Labor Standards Act, Maryland wage and hour laws, fraudulent inducement, breach of contract, and, negligent and intentional infliction of emotional distress. So you see we have no shortage of legal violations here. The Mazengis said, we're not responding to that. The court said, well, as I mentioned, you can't just ignore this, and we're going to go forward, and we're going to at least get a judgment. And so there was a hearing, and Ms. Mazengo was able to present her facts, and the court issued a ruling finding that the damages included the back wages for including her overtime, and also that, saying that you can't just keep somebody in your house and say, okay, you worked 8 hours. She was entitled to both the time that she worked and the time that she was basically held hostage in the house. She was entitled to punitive damages. One of the tricks, the common denominator in some of these cases, is she actually was given a contract. But then when she came to the United States, because there is a contract required for her to get a visa to be even allowed into the country. When she arrived in the United States, the contract was taken away from her. Her passport was taken away from her to basically further deny her of any rights that she might have, as well as her ability to escape. So the court looks through all this and the amount of abuse that she suffered, assesses punitive damages. There's a $1 million judgment, and the Mazengis are at this point out of the country. And the Tanzanian government promoted Mazengi. So in terms of accountability, we've got a U.S. judgment, U.S. court trying to find some measure of accountability, but we've got nothing, and Ms. Mazengo has had her day in court, as it were, but what's happened to Mazengi? It's like, it doesn't seem like a whole lot. And another case which was brought against It's Kuwaiti government officials, Kamari Saviti, Joaquina Cuadros, and Tina Fernandez. The case brought actually by people on both sides of me, my Tina and Stephen at the ACLU, and their colleagues, because it's been going on for a while. So this suit was filed in 2007. Similar patterns of mistreatment, in terms of they were recruited under one set of circumstances, and then when they got in this case to Virginia to be domestic servants for the two Kuwaiti diplomat, or a Kuwaiti diplomat and his wife, excuse me, subjected to physical abuse, threats, 16 to 19 hours a day of work, deprived of food, and had their passports taken away. In this case, the State Department actually asked Kuwait to waive the individual defendant's sovereign immunity, so that a case could go forward and there would be some accountability. And Kuwait said no. And at that point, the Department of Justice, which had undertaken an investigation, just stopped the investigation. And so in this case, though, it did go forward, and there was an ongoing effort to get the papers served on the diplomats and the state of Kuwait, which was a defendant in the case as well, and ultimately the case did settle. And I don't know anything further about that. In the case that I worked on, this case was also on behalf or against a diplomat from Kuwait and his wife. And I'm going to talk about that in terms of the legal precedent that established. So that case, and then I think Ms. Benda is going to talk a bit further about the very important role that the Department of State played in the case, because the case, the allegations of the complaint were similar to what I talked about. One of the other allegations, and it is only an allegation because the case was never made it through to a trial or a factual inquest. It settled. Was for rape and other sexual assault. But the case was, first of all, there was a lot of back and forth, and for people interested in the law, and for the accountability piece of this, it established a very important precedent of how you can actually serve the foreign government and foreign government officials. And that you basically the courts were very strong at maintaining separation of powers and not allowing an executive veto of the ability to serve a foreign government. But one of the main precedents that the case established too of what exactly is a former diplomatic official immune from. So is there a blanket immunity? Which is what the Kuwaiti diplomats were attempting to argue. The history of the case is that there was initially a case brought in 2002 while Al-Awadi, the Kuwaiti diplomat, was still a diplomat in New York. And then he was, the case was dismissed because he's a sitting diplomat. He is entitled to immunity. End of the case. But the court, made it a dismissal without prejudice, and then he was transferred. So he was then posted in France. So the case was refiled, and the court looked at it again and said, well, he's a former diplomat now, and it looked at the treaty governing immunity, the Vienna Convention on Consular Relations, and it said, no, as the work for the mission immunity only covers things that were part of his official function. It doesn't cover the alleged mistreatment of somebody who's working for him and his wife in their home. So, and as I said, I think Ms. Benda is going to talk about it more, but there was a very important intervention from the U.S. government in the case, and the Second Circuit, if you put those two things together, they look very similar. So it's but so the Second Circuit Court of Appeals, the Appellate Court of New York, said that there was no residual immunity for these acts, which are outside the official duties of the diplomat, and his wife never had diplomatic, or his wife didn't have residual immunity because she'd never been working for the mission. So, and as I said, the ultimate end of that story was that the case did settle. The laws on the books, the Trafficking Victim Protection Act has been key in really allowing these cases to go forward. Since 2003, there's been an explicit explicit right to bring a civil action for trafficking, and the trafficking and other violations include forced labor. It also includes financial and psychological coercion. So, basically, somebody being impoverished, being indebted, that is a form of coercion, and that's been repeatedly accepted by the courts. And the other options for bringing the case of the Alien Tort Statute, the argument I just came from, we'll see what happens there, but the limitations on the Alien Tort Statute are whether it applies extraterritorial, or the potential limitations, depending on what the Supreme Court does. The two questions before the court are, does it apply extraterritorially, and does it apply to multinational corporations? So the alien tort claims could be perfectly fine against diplomats. One of the big questions and the debates is what constitutes forced, actionable claim. Do you need slave trading? Do you need forced labor? Do you need and other claims such as rape as torture? Do you need state action? How do you prove that if these are acts outside the official scope? So there's a lot of complex legal claims there, and that will probably continue to be litigated in the courts. There's also really important means for relief under wage and hour claims, the Fair Labor Standards Act, state tort violations. So if we can't get all the international law violations, there's still bring a state tort claim for negligence, false imprisonment, intentional infliction of emotional distress. All of those have been really successful in terms of getting some form of judgment. Contract claims and unjust enrichment are other important avenues that the courts have looked at, in terms of really trying to assess what the violations are in the particular cases. So and just in terms of recommendations, as I mentioned, there's the big problem here is not the existence of the law, and is there a violation or not? Because, as I hope I've shown you, there are plenty of violations, but it's what happens when the law is violated, and what's the recourse. So, it's great to get a $1 million judgment from a court, from Ms. Mazengo, but when she's looking at the fact that the person who did this to her, he's getting a promotion, and she's owed, hundreds of thousands of dollars in back pay. I think it was $500,000 in just compensation and overtime pay alone, not to mention the other damages that she suffered. So, there needs to be there's possibilities under United States law precedent that have been done. For example, if a diplomat, in some cases where diplomats have been involved in a car accident, there's been what are called Excrucia Payments, which is the government doesn't, it's kind of what it sounds like. by the good graces. So the government doesn't have to acknowledge that its diplomat committed this horrible human rights abuse. It just has to kind of make it right. So it's like, this woman is owed back wages. Can something be done to, make her whole? So, there's plenty of, that's been done in car accidents, so why not for forced labor? There's also other options, such as investigating and prosecuting diplomats, or if an official has been found by a U.S. court to violate human rights, what's going to happen to the government that instead of punishing him, winds up promoting him? Should there be some ramifications, for Tanzania? So I'm going to stop there. And
so our last speaker is Susan Benda, who, as Jenny has already mentioned, played an important role in the Swarna case. And Susan Benda has taught a lot of us a lot of diplomatic law. So please go ahead.
Thanks very much. Yeah, I guess the challenge we're all facing is to address this problem of immunity, those of us in the small world of diplomatic law, to ensure that immunity is not impunity. And I think, as Robert had said, you made progress even if you're not where you want to be. I was thinking about, Martina, this exercise made me sort of review the chronology and take stock, and I thought, it made me think of an advertising slogan some of you are familiar with, which is, "We've come a long way, baby." And then I thought, no, more like an iconic American poem, like, "And we've got miles to go before we sleep." So I appreciate that there's a recognition that the State Department has. I really appreciate that there's recognition that we have taken measures to try to prevent the abuse of domestic workers by diplomats. There's this centuries-old tradition that diplomats, when they come here, when they travel around the world, get to bring servants with them. I mean, it's envisioned in the key international document, the Vienna Convention on Diplomatic Relations, that diplomats have personal servants. And so there are visas issued to them, and they've always been conditioned on contracts. And no, we're not that stupid. We know that it's a piece of paper, and we want to make sure that it's worth the paper it's written on. But there have been efforts over the years to try to do things to make sure that when people who enjoy immunity, bringing workers into this country, are not free to abuse them. Now, you probably know, but the Vienna Convention provides diplomats with with a whole package of important immunities. The key ones here is that they're immune from civil jurisdiction, which means you can't sue them, which means you can't serve them, has been pointed out. And they're immune from criminal jurisdiction, and they're inviolable. So basically, that's a pretty good deal. Well, let's hope it doesn't, we don't think it attracts criminals, but let's say it's not bad. We've done something naughty to have that package that we don't have. Now, seriously, it's obviously, governments around the world, this is a treaty that was negotiated in 1965, and, is it 1961? 61. Anyway, this treaty reflected in that part customary international law. I think it's been a law for hundreds of years, and that the king can't send his messenger unless the messenger is sure not to have his head cut off. And when this started, it was all guys, so the pronouns are okay, I think. So the idea is you can't do what you need to do if you're not immune from everything, 24/7. So I want to talk for 2 minutes about sort of what's happened on the side where we got a pat on the back, which is the preventative work we're doing and the statutory framework for that, and then a little bit about the cases. And I look back at I'm going to go back all the way, not very far, to 2008. There was a GAO report written. Chantel is so lousy for lawyers. Here it is. Isn't that pretty? But it said, it looked at U.S. government efforts to address alleged abuse of household workers by foreign diplomats with immunity, and it concluded it could be strengthened. That was 2008. That's when I got this job, and they started working on diplomats, and they said there are 3 problems. One is that they talked about the 3 problems of criminal law enforcement, that immunity constrains law enforcement, that these workers are particularly vulnerable because they know the people who employ them are very important people, and third, the State Department lawyers can't figure out how to help law enforcement. So the big 3 problems, we were right up there. Number 3, the State Department's taking too long to figure out how to help investigators work with the fact that there are international law protections for these people and sort of what can be done to criminally investigate them. I should pause by saying the State Department doesn't take, if there's a civil lawsuit filed against a diplomat, what our role would be that the diplomatic mission could come to us and say, would you please provide us with a certificate of immunity that this person is a diplomat so we can tell the court this person's a diplomat and they're immune, and that's what we do. And of course, folks, that's what we get abroad, right? That's what happens. So in the civil case, that's our basic role. They come to us and ask us for status. You know, and sometimes they don't have status. There's a case right now where there's some adult children and, you know, not everybody with a diplomat necessarily has status. So that's our role in a civil case. In a criminal case, if the prosecutors can get enough evidence, given that they can't do all sorts of things they can do to mere mortals like you all and me, there are serious impediments to law enforcement investigations. But if they get to the point where but for immunity, they do have a crime that they would prosecute, then, and only in these criminal cases when a U.S. prosecutor has that level of, when they're ready, we will then ask the state to waive the immunity of that diplomat. And if the diplomat, if the government who holds the immunity, not the individual, if the government refuses to waive immunity for a diplomat who would be charged with a felony crime, then we require the diplomat and his family to leave. So we do, this applies to all crimes, including trafficking-related offenses. But it's a very difficult threshold to reach because a lot of these, well, of course, if there are crimes happening, they're happening in private residences, which always makes them difficult. In this case, the residences are inviolable, you can't go in there, the family members don't have to talk to you. I mean, it's very difficult. And there was this one case where we did request a waiver, and there was a departure. Okay, so in 2008, the Congress passed the Trafficking Victims Protection Reauthorization Act. And that had a provision that changed the way the State Department looked at these cases because it said that anyone who gets this kind of domestic worker visa, now you can sound really in the know. You say, oh yeah, them A3s and G5s, those are the letters and numbers that go with these domestic worker visas. It said to the Secretary of State, I'm looking at you, and if you find that if you find credible allegations that any domestic worker employed by a diplomatic mission has been abused or mistreated, and you find that the employer, the foreign government, where it also applied to international organizations, that they tolerated the abuse, you make those two findings, then you must suspend for that organization, say the diplomatic mission of Tanzania, all A3 worker visas. So nobody at that embassy will then be able to have a domestic worker. And this was a way to try to add some leverage to people who have immunity. But so again, to try to limit the impunity. And that's the statute that's in place today. So there's that suspension provision. It added more recently that when the Secretary looks at these allegations, she has to, when she's looking to figure out if the allegations are credible, she has to take into account whether there has been a final judgment in one of these civil cases, and she has to take into account whether we've requested a waiver of immunity in a criminal case. So, you know, to give her some guidance. So this law has had a fair amount of impact. The Congress, you know, reminded the Secretary last fall that she expects her to Congress she, did I say that? The Congress it. The Congress it reminded the Secretary that she is expected to take these actions required by law, and to date there haven't been any suspensions, but there's been a lot that has happened within the State Department. We convened a meeting of the DIP Corps in September 2009 and tried, in addition to some long-standing requirements like the contract has to be written, you know, we had a bunch of requirements. The new big news that we came up with was, enough of this, he said, she said, when you pay your domestic worker in the United States, pay them into a bank account, and when she comes to tell us you haven't been paid, we're going to ask you basically to show us the money. Because before there had been, you know, keep receipts. I mean, you know, what can you do? So this was the big new innovation, and we called all the heads of admissions in, this is the Office of Protocol, and said, we're taking this really seriously. We have some new rules. Among them, there's this rule. And there's some others, but we don't have enough time to talk about it all. And the important thing we also said to them was, we are going to hold you sending state governments responsible for this. So You know, you ought to, you know, you might want to be able to find a contract when we say we need a contract, and you might want to be able to find those bank accounts when we come calling. And by the way, it's a crime in this country. So we told them about the suspension provision, that we had this new obligation, and we told them that it's a crime to traffic and what it means, which in part, not what it means, but we also warned them, don't hold passports. You hold somebody's passport, that could be evidence that you're holding them by coercion. So we gave them new marching orders, and off they went. And over time, we added an additional, over time, we also, the next couple of years, we said, okay, we used to tell you you could withhold reasonable amounts for housing and for food. And then some people who are our clients in the State Department, some people that have to administer this stuff said, well, what do I say is reasonable in Manhattan? How do I call this diplomat who's apparently not paying her worker enough if you don't tell me what reasonable is? I don't know what reasonable is in Manhattan. If you're supposed to pay someone $1,500 a month, but you give them room and board in Manhattan, couldn't that wipe it out? You know, I mean, how much does it cost to live in New York City? Or even in Washington, for that matter. So we finally, after we went through a lot of drumming and drumming, we came up to the conclusion that it was just too complicated. And we said, no, you have to pay prevailing rates, minimum wage or prevailing rates, whichever is higher, and you can't withhold anything. First we said for lodging, and then we finally said, yeah, neither for food. So those are some of the highlights of what we've done to try to prevent the abuse and responsive to our new obligations. And I should say there's a group within the State Department for all of free Washington insiders. I mean, I should just tell you, in the State Department, there are lots of different constituencies that work on this. The Office of Protocol basically deals with the diplomatic community here, so they're part of the coalition. The Office to Monitor and Combat Trafficking in Persons, TIP, it's called the JTIP office because it's in the office of the Undersecretary for J, don't ask me, Justice. There's diplomatic security, that's our police that do some investigations of visa fraud and other allegations of criminal abuse, and then there's the legal advisor's office. I've now moved from diplomatic law into law enforcement and intelligence, and my colleague Steve Kerr here is a brilliant guy who's taken over the diplomatic law portfolio. So let me talk to you a little bit about the case law. Because what happens is, so what you're faced with diplomats is they do bad things and you can't arrest them and you can't sue them. Okay, so first, some plaintiffs' lawyers did look at the Benda Convention and thought there was an exception, or looked at the exception there is for diplomats engaged in commercial activity. And they said, well, if you engage a servant, that's like a commercial activity. You're paying them, there's a contract. That looks good, let's try that. And our position in reading the Benda Convention exception for commercial activities did not agree with that interpretation. In our view, a commercial activity is like running a business. But the daily incidental contracts that diplomats enter into are all part of the immunity they have. So whether you're going to a dry cleaner or hiring someone or buying furniture for your house or having a car accident, you have immunity. That's the whole point. You have it all the time. So what happened was those cases, we were, I think, fair to say, we were prevailing. The courts were reading it our way. But there was another quieter case law happening around the country because in addition to diplomats, there are consular officers. Consular officers who don't work in Washington but around the country they have a much more limited immunity for historic reasons that I'm not going to talk about. So they have only immunity for acts performed in the course of their consular duties, which, if you're speaking simple English, you'd say, oh, for what they do officially. And so they were getting sued successfully in various cases, and they would come up with arguments like, this is my favorite, consular officer arguing that I can't do my job if there's no servant looking after my children and cooking my food. And the guy said, well, whether that's true or not, I was thinking, I like that line. Whether that's true or not, I'm not interested. The employment of your servant isn't part of what you're doing for your government. You're not, and so in those cases, consular officers were being held accountable in courts. And then what happened was, let's go back to diplomats. So in 2008, there were some diplomats sued in New York, and we filed a statement of interest in the case the Justice Department filed. In that case to say, yeah, they're immune, by the way, and that commercial activities exception doesn't work. doesn't apply for employment of domestics, and yeah, they're not in the country now, but when you sued them, when you served them, they were accredited diplomats. This is the Sabati case. And we dropped this little footnote that said, we're not today looking at the question of whether you sued them after they left the country, because then we'd have to look at what kind of residual immunity they have, but you sued them when they were sitting diplomats, and so the answer is they're immune. Now, the Vienna Convention says that, in Article 39.2, that diplomats forever retain immunity with respect to acts performed in the exercise of his functions as a member of the mission. So a diplomat retains immunity, it subsists, is the words, with respect to acts performed in the exercise of his functions as a member of the mission. That should sound a little familiar to you. It's sort of kind of like the consular officer when you're doing something officially. And the theory behind that is, the rationale, which we did explain in the briefs we filed, as others more brilliant than us had said before, was when the diplomat is doing something officially, signing a treaty, negotiating some kind of deal, he or she is really acting on behalf of the state. And that would be like suing the state. And we don't sue foreign sovereigns, generally, with huge exceptions, not today being discussed. So everybody agreed. So what we had said or what we eventually said, and I'm giving you a little hint now, was look at the residual immunity of a diplomat. It's much more limited than when they're accredited here, and that's what happened in Swarna. We sat out the district court decision in Swarna. Some brilliant lawyers went in and they made the argument that the diplomats didn't have any immunity. They were sued in France. They were no longer diplomats here, and all they had was whatever you get in that Article 39, and it was definitely less. And and they said it much more elegantly. And the court said, that's right. The employment of a domestic worker is a private act. It's not official. It doesn't bear any relationship to the functions of a diplomatic mission. You didn't need to employ that worker in order to represent your government. You didn't employ that worker as part of implementing any government policy. That worker is at home taking care of your babies and children and your laundry. And even if, as they always argue, she once in a while served at a dinner party that was part of your official job, well, hell, that's a tangential, the court did not say that. The court said, if a tangential benefit is provided to the government, it doesn't convert the nature of the employment. She's still not an employee of mission. That's a private matter. So voila, that's what happened. So Martina asked me to talk about our statement of interest in the Swarna case, but essentially all we said in the Court of Appeals was, he's right, you know. I mean, he had actually filed earlier in another case against the Philippine Perm Rep and said that the Swarna court at the district court level had got the analysis right. So without judging, without applying the facts to the law, we kind of said, that's the way you should look at it. They got it right, so the Boanen court followed Swarna. And so basically in the Court of Appeals, that's what we said. We said the district court got it right, this is what the treaty says, this is what they meant when they said it. And one of the things we mentioned was that we wouldn't assert immunity for our own foreign service officers if they were similarly situated. The Justice Department wouldn't represent them. As far as we were concerned, they were on their own. After they left the country, they got sued. This was all personal and private, and we didn't want anything to do with it. And the big little step we took in that one case was, instead of saying, that's right, Your Honor, analyze it this way, we went the next little step and said, in fact, in this case, the employment was personal. And so there is no residual immunity. So sometimes we don't go quite that far. We just say those are the facts. We just talk about the analytical framework. So I think with Swarna, and what we've seen is that there's a limit to the immunity. There isn't, or at least to the impunity, which is that after diplomats leave, they can be sued. You can even be arrested if you could build a criminal case against them all. But the important thing is they can be sued, and in those cases, many of them have, in fact all of them, as far as I know, have settled. So they don't want to go to trial, and most governments or individuals don't want to face a default. So in the majority of cases, residual immunity has been enough to settle. And I should mention that there's one brilliant lawyer who managed to get a diplomat to settle a case while he was accredited, and that was because, in part because the government didn't want to be on any list of governments who tolerate abuse of domestic workers. So I think if there are going to be criminal investigations, the threat of residual of a limited immunity once you leave office, the possibility that you're going to be on a shame list. I mean, I think we're making progress, and I think I'm over time. Thank you.
So I'm now going to throw it out to all of you. I'm sure that there are some burning questions in the audience, either on the government contracts issue or on the diplomatic accountability issues. So who would like to be first, please? And please say your name and your institutional affiliation, and then your question.
Of course, thank you. My name is Devin Chafee, and I'm with the American Civil Liberties Union. And my question has to do, going back to the human trafficking in U.S. government contracts that third country nationals issue. And I want to get back to something that Stephen talked about with regards to the lack of accountability and enforcement mechanisms. And specifically, I wanted to ask Mr. Reed, it was really interesting to hear you talk about the increased education in media and the more cases that are being brought. And I think it's quite likely that when it comes to certain crimes, that media is in fact serving as more of a deterrent than it was when it was first passed. But I think that what we've seen is that despite extensive documentation, and not just by the ASIL, but by Inspector Generals of the State Department, Defense Department, Special Inspector Generals for Iraq and Afghanistan, have all documented this serious, widespread problem of forced labor and trafficking in third country nationals, but we haven't in that area seen, I think, any criminal cases move forward. And so I was wondering if you could talk a little bit more specifically about why you think that is. Are you getting referrals that touch on those issues or not? If not, why not? And if you have any thoughts about what could be done in order to ensure that there's greater accountability when it comes to those types of abuses.
Sure, I'd be glad to talk about that. We've had one case that came up that I classified as a trafficking in persons case. It dealt with passports. Pulling passports away from people that were employees.
I think it needs to be closer.
And we brought that case up through the command channels and over to justice. They took a look at it, and they believed that looking at the fact pattern, the facts and circumstances involved, that it didn't amount to the passports were taken more than for a temporary purpose, and not for a purpose of that would qualify them sufficiently to prosecute, and so they didn't pursue that. I think that kind of provides some kind of inkling into how maybe we ought to be looking at these cases. A lot of the fact patterns that people talk about, where you talk about wrongful imprisonment, you talk about sexual assault, you talk about assault consummated by a battery, you talk about theft of their property and their possessions. A lot of those are common law crimes that media clearly would apply to, and you might be muddying the water if you try to throw it all under the umbrella term of trafficking in persons. Yeah, perhaps that's too sophisticated a way to look at some of these cases. When we look at fact patterns that come up through the department, I look at to find out what is the gist of the crime that was involved, regardless of the employment relationship, because there are very few employment relationships that give you immunity or impunity from prosecution just because they're your employer that did it to you or you did it to them. So from my perspective, I'm looking at what the crime was, and if that crime can qualify as a federal crime under the federal statute as a felony, then that's a qualifying offense that should at least be transferred over to justice for their review. I will tell you that I've been doing this since the inception of the MUTA statute. Every case that comes through the Department of Defense, through defense channels, comes through me. I have not yet not sent a case to the Department of Justice that's come up through the chain. So there could be a problem out in the field with the fact that they're looking at these things under these terms that they are not familiar with, and they're not pursuing it there, and they're trying to find the hard way to get a result rather than looking at the easy way to get a result. The key, do you want to open up a contract fraud investigation, or would it be easier just to do a larceny case? I don't know. I'm just saying that if you can boil it down to common denominators and what I would call common law crimes that are qualifying, it may be easier to prove. It may be something that you can satisfy the requirements for. The other thing about why this is transforming into a larger number of cases, again, is remember the statute, she was talking about how it was broadened on gradual, this baby step broadening of the statute. Well, if you looked at the history of MEJA and the expansion of MEJA and the Patriot Act expansion and the limitations in the Patriot Act that people subject to MEJA don't fall into that jurisdiction, and all those pieces of legislation where they do it piecemeal, gradually the ripple effect is getting bigger, but it's not like it was an omnibus bill that all of a sudden covered the whole waterfront. And so if you have to find out when the offense was committed to make sure that in that 2-year window between the first statute and its amendment is when you had jurisdiction. We had some cases that were out of Bosnia Herzegovina that got a lot of publicity about this thing. But unfortunately, from the military's perspective, it preceded all of these statutes being implemented for our purposes. So there wasn't much we could do about it. But gradually these things fall into it. There was a mention of the 2008 statute. The Department of Defense has been a full partner in all the meetings and all the initiatives going on zero tolerance for trafficking in person. We have those programs in our law enforcement community. And again, I told you earlier about the difficulty of making a pronouncement here in the Pentagon and getting the guy that's on the ground in Afghanistan to hear it. Okay, that's a long chain of events, and the guidance required to do that. But we're getting better, and that's why I'm saying I'm hopeful, and I think that with time, with people getting the experience, that these cases will be accepted more often than they were maybe earlier on, where they're just too tough to take.
Other questions? Yes, please.
I'm Julia Davis from the International Law Institute. My question is on government contracts. I think Stephen Watt and Robert Reed, thank you. What is your experience with the civil side of government contracts, with if these type of offenses occur, that they become a term of the contract, and the contract can be terminated, there can be debarment for future contracts? Thank you.
There are procedures, administrative procedures, that would allow a contractor the contract to be suspended or debarred from further contracting. But in our research, there has been no debarment procedure. There has been no exclusion of any identified contractor for involvement in trafficking enforcement. But there is a procedure available.
I can't answer that because I readily admit that I'm not a contract attorney and I don't work in that contract debarment process and procedures. I am aware of the fact that we have federal acquisition regulation provisions that talk about requirements on contractors to make sure their contract employees are aware of trafficking in persons issues. We have training requirements for them and all of that. But as to the actual debarment process, I'm not qualified. It's not my area that I deal with, so I can't answer that. And if there aren't any debarment actions, I couldn't offer a hypothetical reason why. So I'm sorry, I have to beg off.
So if I can just jump in on that, I'll sort of step out of the moderator role. The FAR clause is subpart 22.17, and that FAR clause, which is required to be in all federal government contracts, not just in DoD contracts, that contract clause stemming from FAR subpart 22.17 says that no federal contractor can use forced labor in the completion of a contract, that no contractor employee can engage in a severe form of trafficking, which includes forced labor or forced prostitution of adults or child commercial sexual exploitation of those under 18. And then the third provision, which is a little interesting, and goes to the question of what the government has characterized as demand for trafficking, demand for prostitution. No employee of a U.S. government contractor can purchase a commercial sex act. That's also in the FAR clause. There is, I think Stephen's absolutely right that there haven't been any debarments, but there's a whole list of possible remedies against the contractor. But one of the main problems is that it's all based on self-reporting, and what Wes is holding up is the actual subpart, which is in your materials, in your packet. I'm happy to talk to you about the FAR clause afterwards if people have questions about that.
Thank you.
Okay, two more questions. Does anybody have a question?
Well, I was going to mention the same thing. I have some experience with Department of Labor doing debarment for EEO violations domestically. So it seems natural that instead of trying to get prosecutors in Duluth to, bring a case that happened in Afghanistan, that you would use debarment. And it also has the benefit of going after the deep pocket because if you get the prime and they're responsible for what happens, with their subcontractors. And the other thing, so I'm curious what agency within Department of Defense does that, and can't we knock on their door? And the other, it was just an observation that this was supposed to be about spreading democracy in Iraq and Afghanistan, and it looks like we're spreading slave labor, which isn't exactly a U.S. principle.
Which part of DOD would handle that part?
It gets referred to DOJ.
So the contracting piece, one of the major problems that we've seen in actual implementation of the contracting piece is that the contracting officers were not actually trained. And so when one large contractor said in a conference in a public setting that they had a violation of the FAR clause, and they attempted to report that to the contracting officer, as they are required mandatorily to do under the FAR clause, the contracting officer had no idea what they were talking about. And so since then, the Department of Homeland Security has started a training program within the National Defense Acquisition University. And so it's actually the contracting officers that are responsible for this. Other questions? Go ahead, Katie.
Hi, my name is Mitch and I'm Katie Whitcomb. I'm from the Naval Academy. I was wondering, because this will be toward Mr. Watt or Mr. Reed. Right now, there's some analysts believe that the military should be indoctrinating or having more involvement with contractors in their culture. And there's been a push for more things to be done besides like the Joint Contracting Command or the CONUS agreements. And I was wondering, do you see that, to what extent do you see civilian contractors being involved in military culture, and if that will actually affect change in that policy gap that you were talking about earlier, how there's things going on that aren't within jurisdiction?
Well, I mean, the interaction between the department and the contractor has grown exponentially over the last 20 years. As far as the contractors performing duties on behalf of the Department of Defense overseas. And the difficulty, of course, there is when you contract out, then the contractor is responsible within the certain parameters that the department gives them. Acquisition and logistics is the portion of the Department of Defense that deals with the contract provisions and the procedures that go with it. One of the problems that we had, just if I can transition a little bit, one of the problems that we had with contractors is as soon as they got wind of the fact that there was an ongoing investigation or an offense committed, they whisked their employee out of their contractor employee out of the country back to the United States or their home country, essentially moved them away. And we had to go to the Deputy Secretary of Defense to issue a policy memorandum that basically said when an accusation is made against a contractor employee, that they cannot be allowed to be removed from the theater without the express authority of the combatant commander in that theater. And the objective was to freeze the crime scene, if you will, in order to do the investigation and complete the investigation, rather than allow contractors to extricate their employees and contract employees out of the theater and make it more difficult to investigate and perfect an investigation. So those types of activities, that kind of activity, as we experienced them, started creating these new policies and procedures in order to deal with that, to thwart that behavior. Again, that's part of the growing problem. And the more that you have contractors with the Department of Defense, the more they have to work together and they have to train and they have to understand each rules and regulations and how they interact with each other in the theater. Because as a general proposition, there is no immunity that is applicable to them. What's applicable is getting a good fact pattern to operate on and not allow circumstances to make a weak case. You get a weak case, that guy in North Dakota is not going to take it. I can tell you that right now. So, you know, we used to have in law school the silver platter doctrine. You just got to hand it to them on a silver platter. I mean, that's your objective. And if you don't, to the extent you don't do that, you run the risk that they'll just decline. They'll find some reason why the evidence was insufficient to pursue it.
So I think we have to wrap up. Many of you may have additional questions. Feel free to come up and speak to the panelists individually. Thank you again to all of you for coming. Thank you to Jenny Green, Stephen Watt, Susan Benda, and Robert Reed. I think there are basically 3 takeaways from today's meeting. One is read the footnotes, especially if they're drafted by Susan Benda. The second is, I think it's probably become clear in the course of this discussion that for some victims of human trafficking, their only option is civil litigation before U.S. federal courts, because the prosecutions simply aren't happening. And so I think all of the panelists are really engaged in an ongoing and continuing battle to end impunity in these 2 areas of human trafficking, and I thank all of them for their contributions.